Good evening, everyone. I'm Ankit, and you're watching the Indian Express analysis, which is on the StudyIQ IAS English channel. Now, today is 19th of March, and we are going to discuss important news and articles from our today's perspective. Right. Now, in this discussion, we are going to cover important news articles which have been given in the newspaper. As I have already told you, today is a very polity loaded newspaper. So, in our today's discussion, we are going to cover these many articles. We'll start off with the Competition Commission of India. Why we are discussing this Competition Commission of India? Because this body has actually raided the premises of advertisement agencies based on the information that they were colluding in order to set the prices. Now, any anti-competitive practice, when it happens in the economy, you can understand it distorts the free trade and commerce that should happen. And this is the responsibility of Competition Commission of India, so as to make sure that there is a free trade going on in the economy without the interference of any large corporation, so as that it makes the market detrimental for small companies, right? Now, this is a statutory body which is important from GS paper 2 perspective, as also this is a sectoral regulator, as it ensures free competition in the market, right? So, important regulatory bodies and authorities, these are important from GS paper 2 perspective, right? Then we'll be understanding the basis of provision of reservation on the basis of religion. Now, this is a very fraught topic, and we have understood that many state governments, they have extended benefits to many communities solely on the basis of religion. But what does the Apex Court of India feels about it? We'll try to understand this in our today's discussion. And this article primarily appeared in the newspaper because the government of West Bengal has highlighted to the High Court and the Supreme Court of India that it is going to first of all conduct a survey in order to ascertain which of the following communities are backward, and then accordingly provide them with the reservation. Now, these reservation policies, these are extended under the Article 15 and 16 of the Indian Constitution. Therefore, these are a part of fundamental rights. Therefore, it becomes important from, again, GS paper 2 syllabus. Then we'll be understanding whether or not Lokpal, does it have its jurisdiction over the High Court judges. Now, this issue actually was quite in news in the month of February. Now, this is again in news because the Supreme Court of India is actually considering this case, or whether or not Lokpal has its jurisdiction over High Court of India. Now, actually, in February, Lokpal, what it did, that it passed a judgment highlighting that High Court judges were indeed actually under the jurisdiction of Lokpal. However, that judgment of Lokpal was stayed by the Supreme Court of India until or unless it decides on the matter of the jurisdiction of Lokpal, right? So, this again is a statutory body. Therefore, it makes it important from GS paper 2 polity syllabus. And then on the fourth article, we'll be discussing how is death penalty awarded in India, because the district court in Manpuri district of Uttar Pradesh has actually awarded death penalty to 3 people in a crime which happened back in 1981. Now, the district court has highlighted that this crime was actually rarest of rare case, and in that regard, according to the Supreme Court directions, the court extended the death penalty, right? So, we'll understand what are the conditions that actually favor or that does not favor awarding death penalty in certain cases. Again, this is a part of fundamental right, that is Article 21. If you can recall, you have a right to life and liberty, especially unless it is provided by procedure of law or established by procedure of law. So, this is again important from GS paper 2 syllabus. Now, a break from polity, will be discussing the fifth article, which describes whether or not elephants can they be used for a temple or festival celebrations in India, because as you can understand, many of you have even seen that elephants are indeed a part and parcel of life in the southern states. Primarily, they are used in many temple as well as festival occasions. So, what is the legislation in India? Does it actually is legal? We'll try to find out in our today's discussion. And as I told you, this is a break from polity. Therefore, it becomes important from GS paper 3 perspective, because you can understand elephants, they are a protected species under the Wildlife Protection Act. Again, we'll be discussing a polity part, because we'll be discussing the changes that have been asked to be made in MGNREGA, especially by the leader former leader of opposition, Mrs. Sonia Gandhi, and she raised this issue in a 0 hour of the parliament. So we'll try to first of all understand what is this 0 hour and what is the basics of MGNREGA, how this should be changed in recent times. Now this again is a part of polity syllabus, and especially it is important from your prelims perspective, because parliamentary devices, proceedings, etc., in one way or the other, they have been asked quite frequently in the prelims examination, right? So these are the articles. Good evening, Augustine, Yashi, Baga, Jatin, Sarang, Shweta, Sejal, Kartike, Saujanya. Good evening. Saujanya, not good morning, good evening. It's 4 p.m. in the evening. Yes. Now, if you like this session, a humble request from my side, please do not forget to give us a thumbs up, and also after this video end, in the comment section, go and write a very nice comment of whether or not you find this session fruitful for your UPSC preparation. Now, the notes for this session, as you can understand, will be available on my Telegram channel called as ATS Live. So you can search my Telegram channel going on the top right hand corner of your mobile app, typing the words ATS Live, and it will take you directly to my channel, or also you have an option to scan this QR code. Okay. Now let us understand, or let us try to solve the practice question that I gave you yesterday. Now, good evening, Niranjan, Sejal, Niranjan, Kartike and Sejal. Yes, this practice question, which of the following best describes the term Samanvay, sometimes seen in the news? Please let me know which is the correct answer. Quickly. I want to see whether or not you have revised your syllabus or not. Bharat Kalor, yahan nahi, after the video ends, please. It's okay, Saujanya, I was just pulling your leg. Sarang says option D, Yashi says option B. तो दोनों तो सही नहीं हो सकते ना. Either one of them has to be correct, or even A or C. Like Bhagat Spinks is saying option C. Saujanya, good evening. Yes, indeed. Say, I want to appreciate few of the people who write answers daily. Sejal is one of them, Saujanya is one of them, Lydia is one of them, and also Vishwabrat, who is not present today, I guess, but he also writes answers quite frequently. So I want others also to emulate these people so that they write their answers. Now, actually, Samanvay was actually a data sharing and analytics platform. Cyber tracking and mapping portal, we did it yesterday. It is what we did yesterday. Others are provides forensic support. There's a different platform for each and every one of them. This was Pratibim module, right? Well, if you don't understand Hindi, Pratibim actually means reflection. Now, let us move to the first article of the day. This article appeared on the economy page of the newspaper. Now, economy is usually in the backward side of the newspaper, but today it is just on the opposite side of the advertisement, that is the front page, right? So, there is no actual page given in the today's newspaper. It is given as an economy section. Okay, so this article, it actually says that the Competition Commission of India, it has raided the advertisement major companies and also the broadcasters body, right? So let us understand the context of this article. Now, CCI, it raided the offices of media agencies as well as the Indian Broadcasting and Digital Foundation, which is the apex self-regulatory authority of broadcasters themselves, over the alleged fixing of ad rates and discounts, right? Now, earlier there was this two important sports broadcasting company in India, that is Viacom 18 as well as the Star Sports. Okay, now these two companies, earlier actually there were two companies, so they used to compete with each other to provide the most actual and the most beneficial ad rates for the company. But now we have seen that these two companies have merged into one single large company, right? So in terms of competition, when two of the large companies, they merge together, in terms of overall competition, it reduces. So it's quite possible that these two entities will now collude within themselves, that they'll set the ad rate high, because the companies who are actually paying for the advertisement rate, they have no other option, that the amount of competition in the market is quite less, and this is quite detrimental as far as the Competition Commission of India is concerned. So actually the Competition Commission of India, it has raided the offices of these media agencies, citing that there might be price collusion just because IPL is going to happen, and we understand during IPL the ad rates, they are skyrocketing. Now, price collusion refers to the practice of manipulating advertising rates offering discounts or selective discounts only to the companies that you prefer, and the inventory that you can say, I do not have any ad slots left, so whatever slot that I'm offering, please take it and pay me very high rate. So this distorts the free market and fair market competition that should happen in any economy for a very efficient and effective discovery of price. Now this practice is actually frowned upon and it is prohibited by Competition Commission of India. So it is actually the responsibility of the regulator, Competition Commission of India, to ensure that fair market competition happens, and if any act by the companies themselves it is trying to prevent this fair competition from happening, this Competition Commission of India can take many measures, which includes raiding of the sites of these companies. Understood? So in this regard, the Competition Commission of India from our prelims perspective becomes very important. Now Competition Commission of India, it is an autonomous statutory body which was established in 2009 as per the provisions of which act? Competition Act of 2002. Now earlier, back at the time when license permit Raj was there in the economy, there was this act known as Monopolies and Restrictive Trade Practices Act 1969. Now this MRTP Act, what it used to do was that it actually prevented monopolies from happening in Indian economy. But as against just preventing monopolies from happening in Indian economy, what we saw that this act itself stifled the normal competition in the market. So after India got liberalized, we felt that there was a need for an entirely new competition act, and hence this act was repealed and a new act was enacted known as Competition Act 2002, and this act was enacted due to the recommendations made by the Raghavan committee. Now such recommendations made by expert committees, their names are very important in some cases, so please remember that this was established based on the recommendation of Raghavan committee. Now this is a quasi judicial body. What is a quasi judicial body? That it has some kind of judicial powers, that it can summon the officials, it has the power of a civil code, it can punish the officials by making some kind of a fines. So these are the powers given to quasi judicial body, that some of their functions they mimic the judiciary. Also, the aim of this body, as you may have already know, it is to manage and enforce the act so as to ensure fair competition and protection of consumer interest. And who are the consumers in our economy? People like you and I. Suppose if there is just one mobile phone company in India as against many companies which are present today. So mobile phones are very desirable and are essential in our day-to-day life. So what if we go and buy a very simple phone and that company might demand you have to pay me 2 lakhs for a mobile phone? So will it be just? No, right? So that is why we need a bodies like Competition Commission of India. Now the Competition Commission of India, in terms of the membership or in terms of composition, it composes of 1 chairperson and 6 members who are appointed by the central government. And what is the qualification of these members? What they need to have is that chairperson and every other member, they should be a person of ability, integrity and high standing, who in the opinion of government, and also they should be qualified or should be the earlier judge of a high court, right? So either they should have been the judge of high court or they should have been adequate qualification to be appointed as a judge of high court. Also, in addition to these, they need to have a special knowledge, professional experience of not less than 15 years in international trade, economics, business, commerce, law, finances, etc. So these are the relevant qualifications which you need for a member to have before or not they can be appointed as the member or chairperson of CCI, right? Now, what are the objectives of CCI? First objective is naturally to promote competition. As you can say, earlier there were many companies in India, like Vistara was the airline, government had Air India. Also there were low cost option like Air Asia, which was again handled by Tatas. Air India had Air India Express, right? So what happened after the Air India was sold to Tatas? Tata decided to merge 2 full service airlines into one, and they decided to merge 2 low cost airlines into one. Now before they were merged, you can understand when 2 big airlines are merging, it will naturally reduce the competition in the market. So they had to take the permission from the Competition Commission of India, saying that these are the measures that we are going to implement, and we are not going to levy high ticket prices just on the destination where only Tatas will operate their flights, right? So this is how CCI operates perfect competition in the market, which is very necessary in order to discover the prices in a fair and efficient manner. Also, it eliminates adverse practice. That what if, suppose there was this instance where Google, it controls the apps which are installed in the Google phone by registering them in the Play Store, right? So suppose Google denies any of its rivals, suppose it denies Map My India to register its own app services on the Play Store app. So this is actually an adverse practice because Google is stifling the innovation in the maps market. So this will actually be disallowed by the Competition Commission of India. So it eliminates adverse practices. If any companies decides to stifle its own competition, suppose Google has GPay, so what if Google decides not to list PhonePe and Paytm on its app? So this again will be an adverse practice. Similarly, it ensures that consumer interests are taken care of. Now, what is the consumer interest? That whenever we are going to buy any goods and services in the market, we need to have more than one alternative. Then only using our mind we'll be able to decide which good is the cheapest, which good is the best. So that alternative you should have. So this is how this Competition Commission of India ensures consumer interest. Also, it supports freedom of trade. What is freedom of trade? Suppose there were many airlines in India, right? So in addition to Tata's, SpiceJet also operates airlines, Akasa Air also operates airlines, Indigo also operates airlines. So what if Tata's make sure that they have all the premium slots in the airports and they deny similar slots to other airlines? So this is not freedom of trade. That is, in any offering of goods and services, there should be fair competition in the market. So any decision taken by a company which prevents fair competition from happening, it distorts freedom of trade, which is not allowed by the Competition Commission of India. And in doing or bringing any regulation in the market, CCI also ensures that every stakeholder is engaged with it. For example, not just customers, but companies itself, they will send the representatives to CCI highlighting their case and then giving the reason why they are taking such measures, and only after receiving the consensus, only after taking care of all the interest, then only CCI will bring any interest. So these are the key objectives that the CCI does on its day-to-day basis, right? Vishwabrat, good evening. I have started the session late. No problem, Vishwabrat. Now, there was this recent development with respect to CCI, that there was this draft digital competition bill that was passed by the parliament. Now, what this draft digital competition bill does is that it brings different kind of regulation. Now, before this draft digital competition bill was brought forward by the parliament, the only power of CCI was that of ex post regulation. Suppose only if one company decides to do something, only after that event has to happen, then only CCI can say that that particular move is allowed or not allowed. So suppose if Google actually has its own payment service known as GPay. So what if Google decides not to enlist PhonePe and Paytm on its app, right? So actually, when it will ban these apps from being registered on its Play Store, then only the CCI will be able to pass the judgment on whether or not this measure by Google is right or wrong, right? So this is what ex post facto is, that only after the decision has taken place by the company or anti-competitive practice has happened, then only the CCI will be able to pass its judgment. But in the digital economy, it was felt that while regulating, only after the decision is made, then only the CCI is able to pass its judgment. This is actually detrimental to free market interest. So it was felt that there should be given powers to CCI, that it should act even before the anti-competitive practice should happen. So if CCI has the power to act even before the anti-competitive practice happens, that is called as ex-ante regulation, and this is very necessary in the digital era, because companies, they make many measures that in future might be detrimental to the interest of the market and economy, and therefore CCI needs power even to act on a preemptive basis, just like in this example, right? So this is the difference between ex post regulation and ex ante regulation. Ex ante regulation allows the CCI to preempt the moves of the company and pass its judgment even before the anti-competitive practices has happened, whereas earlier the anti-competitive practice will happen before, and then only the CCI will be able to pass its own judgment whether this is correct or not correct. Understood the difference? Good evening, Anchal. Good evening, SS Talks. Understood this difference? Any doubt you have in ex post and ex ante regulation? If you don't have any doubt, this is the question that we need to solve right now. Consider the following statements. Ex post facto framework allows regulators to preempt and prevent companies from indulging in unlawful practices even before they take place. An ex ante framework means that the regulators can use its power of enforcement only after the unlawful conduct has occurred. Right? So, Sarang says option D. Sarang is usually the quickest to answer. So, let me know which of the following is correct. Well, I told you, right, ex ante is actually preempting the CCI or allowing the CCI to preempt the action and take measures accordingly, whereas ex post meant that the anti-competitive practice should happen and then only the CCI can act. So, this is actually an exchange statement. I have actually exchanged ex post with ex ante here, so both statement becomes incorrect. Therefore, we have to identify correct answer. Hence, option D is correct. Yes, it's the other way around. Baga Springs, you're correct. SS Talk, Sarang, Yashi, Saujanya, all of you are right. Now, let us move to the next article of the day. This article appeared in the page 9 of the newspaper, and it states that Bengal government has highlighted to Supreme Court that it will conduct fresh exercise for identification of OBCs in the state of Bengal, right? Now, why has it the Bengal government decided to conduct the survey to identify OBCs? Because earlier the High Court of West Bengal, it actually invalidated the measures of Bengal government to provide reservations to 77 communities, because out of these 77 communities, 75 communities were belonging to Muslim religion. Now in the judgment, the Bengal High Court, the High Court of Kolkata, it highlighted that the government can't just provide reservations solely on the basis of religion. So what is actually the provision of providing reservations on the basis of religion? Let us find out in our today's discussion. Okay. Now if you look at the Constitution of India, in Article 16 subsection 4, the Constitution says that the states have power to provide reservations in favor of any backward classes of citizens, right, which in the opinion of state is not adequately represented in the services under the states. So it actually gives state the power to provide reservation to any category irrespective of religion, provided that that particular community is not adequately represented in the services of the state. So there is a condition, okay, under the Article 16 subsection 4. Now historically, reservations to Muslims community have been allowed in both scheduled caste category as well as OBC categories, but in most cases we have seen that the reservations to Muslim community have been provided under the category of other backward classes. For example, in states like Kerala, the reservations are applicable to Muslims community from 1956. In Karnataka, it was started to be given from 1995, and in Tamil Nadu, it was started to be given from 2007 onwards. Now Kerala, in its many commissions that it has set up, it has found that Muslims as a whole could be considered as a socially and economically backward classes, right? Similarly, Government of India at the time when Manmohan Singh was the Prime Minister, it set up a Justice Rajendra Sachar committee in 2006. Now this committee, it found that the representations of Muslims, OBCs, it was abysmally low in the central government departments. Hence the benefits of even the OBC category, which was extended to Muslims, it has not actually resulted into better socially and educational status for the Muslim communities, right? So indeed, actually, on the basis of religion, the reservations are provided to many communities, including the Muslim community, and this is actually sanctioned under the Article 16 subsection 4 of the Constitution, right? But Supreme Court in Indira Sani judgment, which was given in 1992, it stated that no classes of citizens can be classified as backward solely on the reasons of religion, race, caste, sex, descent, place of birth, residence, or any of them. So in a way, Supreme Court actually said that these categories are actually relevant from consideration in order to provide reservation, but solely belonging to one religion or one caste, it does not make you eligible to get reservation. Rather, you have to ensure that that particular religion or caste for which you are providing the reservations to, they are actually socially and educationally backward. They are actually not represented adequately in the services of the government, and only when you find that these backwardness exist for that community, then only you can extend the reservation. Understood the difference? So, highlighting the judgment given by the Supreme Court in Indira Sani case, High Court of Kolkata, it actually in May 2024 struck down the OBC reservation which was provided by the government of Bengal to 77 classes, out of which 75 classes belonging to the Muslim community, because the High Court of Kolkata, it felt that reservations were provided without using any objective criteria, and religion indeed appeared to be the only criteria based on which these communities were called as OBC communities. And the reason is actually very sound, because if you provide reservation to everyone, how will reservation benefit the people who actually need it the most? You need to identify among these communities who are the most backward communities, who are the most excluded communities, who are the most socially and educationally backward communities, and then only you have to provide reservations only to those communities. Hence only you can benefit, or you can expect the reservation policies to benefit the people who need it the most. Okay, so this was the criteria based on which the government's decision of Bengal was invalidated by the Kolkata High Court. Now, whether or not religion can serve as a parameter to provide reservations under the scheduled caste category, right? Now, in this Article 341, subsection 1 of the Indian Constitution, it gives power to the President of India to specify certain castes, races, tribes, or parts and groups of within certain caste, races, and tribes for the purpose to be provided as reservation under the category of scheduled caste, right? So, according to this particular article, the President of India, under Constitution Scheduled Caste Order of 1950, President of India passed an order which contained a list of categories or caste who will be called or who will be provided reservations under the scheduled caste, right? Now, this list is provided with respect to every state. Now, earlier this was only provided to Hindu community. There was this certain demand from other religions also. So, a clause 3rd was inserted into this order which provided that no person who professes a religion other than Hindu, Sikhism as well as Buddhism shall be deemed as a member of scheduled caste. So, in our current circumstances, member of these three religions, that is Hinduism, Sikhism and Buddhism, these people only are eligible to get benefits under the category of scheduled caste. Now, the question might appear in your mind, what happens if a member belonging to scheduled caste community, for example from Hindu, what if they decide to convert to Christianity? So, will or will they not be eligible to get benefits under the reservation policies, or will they not be categorized as a scheduled caste member, right? Now, this matter also reached the Supreme Court of India in Susai versus Union of India case in 1985, because a cobbler in state of Tamil Nadu, he was the member of scheduled caste community, but he decided to convert to Christianity. So, technically he was not eligible for reservation. So, he went to Supreme Court of India, and hearing his petition, Supreme Court of India says that first of all, the person will not be eligible to be called as a scheduled caste if they decide to convert to other religion, but still they can get the reservation after they provide that indeed after conversion the person has or is suffering from handicaps which was earlier even faced by him when he was the member of Hindu community, and when he will be able to provide that even after conversion, if he feels socially handicapped, if he feels socially marginalized and excluded, then he will be able to get the benefits of reservation. Now, even back in 2010s, the government set up a Rangnath Mishra committee to actually ascertain whether or not the evidences are there so that the members of other communities also face discrimination similar to members of Hindu community based on the basis of their caste. Now, this commission actually highlighted that by all available evidences, there are evidences that although technically in religious terms caste system only exists in Hindus, but we have seen that in practice, there are similar discrimination that happens also in other communities which are very similar to caste-based discrimination. So, according to this Ranganath Mishra Commission, actually the reservation benefit should be available to all religion, not just exclusively to few religion. However, the government of India actually denied the findings of this Ranganath Mishra committee, and it has set up a new committee under the former Chief Justice of India, Mr. K.G. Balakrishnan, to consider whether or not people who have converted to other religion, they are also eligible for reservation benefits or not. So this Ranganath Mishra committee actually recommended earlier that once a person has been included in scheduled caste list, irrespective of the fact that they convert to other religion, still the benefits of reservation and the benefits that are available to scheduled caste member, they should be provided to them. However, this was denied by the government of India, and it set up a new committee under the chairmanship of the former CJI, Mr. K.G. Balakrishna. Okay. So this is the case which is ongoing in the Supreme Court, and the Supreme Court is actually not hearing the new cases regarding to it. Whenever this development happens, rest assured we'll cover it in our today's discussion. So PWDs, person with disabilities, have different reservation. There are separate reservations for PWDs as against caste. Okay. Now, let us see if you can solve this question. Now, in 2023, a question appeared on Article 16, subsection 4 of the Indian Constitution. So, I have actually borrowed the template of that particular question and changed the question as per the today's article. So, let us see if you can solve this particular question. Quickly. I'll get out of your way. Please read it and solve it at the earliest possible time. So, let's see if Sarang or anyone else replies as soon as possible, and what if they reply correctly. Well, reservations under the Article 16 subsection 4 of the Constitution can include religious groups within OBC category, provided their backwardness is established on the objective criteria. Second statement, as per the Supreme Court, religion alone cannot be the sole criteria for identifying a class as backward for the purpose of reservations under Article 16 subsection 4. The Supreme Court, in the judgment given under the Indrasani judgment, it highlighted that religion or caste alone can't be the factor based on which you provide the reservation. Bagas Ping says option A, Sejal says option D, Yashi says option D. Option D. Well, first statement is indeed correct. Well, you can provide reservation to include religious groups within OBC category, provided that you also have to prove that they are indeed backward in nature. You just can't provide reservation to any community based on they are belonging to X religion or Y religion. You have to establish that these classes of people are actually backward in nature. So, first statement is correct. Second, as I have already told you, is based on the Supreme Court judgment of Indrasani case. Now, how if to prove that first or second is correct? Okay, whether first statement or second statement is a correct explanation of each other, you just add after statement 1 the word because, and if it makes sense, you will be able to say that second correctly explains 1, which in this case is true. Therefore, option A is right, because you can provide a religion based reservations under OBC category, but that religion should not be the only factor. You have to also establish that the persons are indeed backward. Okay, so that is why option B is correct and not other options. Now let us move to the next article. This article appeared also on the page 9th of the Indian Express newspaper, and it states that the Lokpal jurisdiction over High Court, this matter is actually in the Supreme Court of India, and it will hear this matter on April the 15th. Now, why this news actually appeared in today's newspaper? It is because Supreme Court yesterday adjourned this hearing to April 15th on a matter whether or not Lokpal has the jurisdiction over High Court. Now, this matter reached to the Supreme Court of India even in February? Because earlier Lokpal in its judgment has highlighted that indeed High Court judges are under the ambit of Lokpal Act, and hence Lokpal can inquire into their conduct. But Supreme Court of India, it actually stayed this order of the Lokpal, saying that this is something very disturbing. So in this regard, let us understand what is the provision given in the Lokpal Act and whether or not High Court judges, do they qualify to be called or do they qualify to be regulated by the conduct of the Lokpal Act, right? Now, Lokpal and Lokpayuktas Act of 2013, according to which Lokpal was set up, it defines public servants under the section 14(1)(f) of the Lokpal and Lokayuktas Act. And according to this act, any person who is or has been a member, officer or employee in any body, board, corporation or authority which is established by an act of parliament or is financed or controlled by the central government, then these members of the company will be called as a public servant, right? So under the definition of public servant, we see that Prime Minister of India falls under the definition of public servant, ministers of the union government falls under this definition, members of parliament falls, even employees of the central government, that is group A, group B, group C, group D, government employees, they fall under the jurisdiction of Lokpal. So what if you qualify this exam and become an IRS officer? Will you be called as a public servant under Lokpal Act? Yes. Whether you be able to qualify the combined graduate level exam of the SSC, will you be called or will you be under the jurisdiction of Lokpal? Yes, you will be. So these people are indeed called as a public servant under the Lokpal Act. Okay. Now, the next question is whether this same designation of public servant, are these applicable on judges and the Chief Justices of India, both of High Court and Supreme Court. Now, according to this, judges of the Supreme Court, they are called as public servants as per the section 2 of another act, that is the Prevention of Corruption Act of 1998. So based on this act, you can safely say that they belong or they are public servants. But indeed, what does Lokpal say about it? Now, Lokpal in its judgment, which it gave in February, it stated that only entities which are established by the Act of Parliament or are controlled and financed by the central government, only the employees or members of these entities are be or will be called as a public servant. Whereas the members of Supreme Court, that is judges and the Chief Justice of India, they will not qualify to be called as a public servant because Supreme Court is not a body which was established by an Act of Parliament. Rather, it finds its origin from Article 124 of the Indian Constitution. So as it is a constitutional body and not a statutory body, therefore judges and the Chief Justice of India or judges of Supreme Court and Chief Justice of India, they will or they are not controlled and financed by the central government, therefore they are not public servants, right? So this, the Lokpal Act actually highlighted that members of the or judges of Supreme Court and Chief Justice of India are not public servants. But what about the judges of High Court or what about Chief Justice of a particular High Court? Now in that case, Lokpal argued that High Court judges, they qualify as public servants because first of all, High Courts were established under the British Parliamentary Acts, that was High Court Act 1861 and Government of India Act 1935, whereas Article 214, which actually mentions the High Court, it actually recognizes High Court but does not establish them, unlike the Supreme Court of India, because I told you Article 124 explicitly establishes Supreme Court, making it a child of Constitution, whereas Constitution of India under Article 214 only recognizes but does not establish the High Courts of India. So according to this judgment of Lokpal, the judges of High Court and Chief Justice of High Court, they are under the jurisdiction of Lokpal. But what about the Supreme Court judgment? Now, Supreme Court actually stated this decision of Lokpal, saying that all judges, be it High Court judges or Supreme Court judges, they are appointed under the Constitution, implying that they are indeed immune from the jurisdiction of Lokpal. Now, this matter is actually under the consideration of the court, and if and when the Supreme Court hears this matter, we will make sure to cover it in our daily discussions. What about autonomous body members? Well, autonomous body members depends whether those autonomous body members were they formed as per the Act of Parliament, then the members are indeed actually eligible to be called as public servant, or whether or not those autonomous organization, whether they are financed by the government, although it is not controlled by the government, but whether or not they are financed by the government, that will also determine whether or not they are public servants. Okay, so let's solve this particular question. With reference to jurisdiction of Lokpal under the Lokpal and Lokayuktas Act, consider the following statement. High Court judges qualify as public servants under Section 14 Act of the Lokpal Act because High Courts were established under British Parliamentary Act and not explicitly created by the Indian Constitution. Now, Lokpal actually gave this argument, but this argument was actually stayed by the Supreme Court. So this statement becomes incorrect, because what did Supreme Court say? That be it judges of High Court or Supreme Court, they are appointed by Constitution, therefore they are not public servants. The second statement, Supreme Court of India is outside the jurisdiction of Lokpal because it is a body established not by Act of Parliament but by Constitution of India. This is correct, and we have to identify correct statement. So option B here is the right answer. Yes, Sarang. Well, Shweta, you can read the question again. Actually, option B is correct. Now, this matter that we are dealing with, the matters of judiciary, what is the structure of judiciary, how is members of judiciary appointed, on what basis can they be removed, all of this is covered in a polity classes, right? So, if you don't understand this concept, do not fear, because StudyIQ is here, and StudyIQ has come up with Sampoorn batch, which is actually a new batch we are forming for morning batch. Earlier the batches that were offered, they have been filled. So, this new batch for morning will begin on 24th of March. So, before that, please make sure to get admissions in that batch. And how to take admissions for that batch? Now go to the StudyIQ website. You have to create an account here. After creating your account, click on Explore Courses. Now, as you click on Explore Courses, you will be provided this sticker, and as you click on UPSC IAS English, these courses are available exclusively in English, even good for students who are belonging to northeastern part of the country, belonging to southern states who are not comfortable with Hindi. We understand this problem. So therefore, these batches, these are available exclusively in English. Right now, this style you can see here, it provides for P2I Foundation or Sampoorn batch, which will begin from March of the 24th. Right now this batch is available at 37,499 rupees, but you can get this batch at a reasonable rate by applying for discounts. The code for the discounts might be flashing on the bottom half of your screen. Click on buy now here. Now here there is an option to add promo code. Click on promo code. Here you can enter coupon code. Now as soon as you click on enter coupon code, write ATS live, okay, and click on apply. As soon as you click on apply, you see the value of course has reduced from 37,499 to 29,999. So this is how you get the maximum discounts on a platform, by using the code ATS live. See, it is giving you 7,500 rupees discount. Okay. Yes, SS Stocks, Yashi, you are correct. Sejal also, Bagas Pinks also, yes. So this is how you register for courses which are available on StudyIQ website. But remember to get the discounts by applying the code ATS live. Okay. Now, this news article appeared on page 12 of the newspaper. It states that the rarest of rare doctrine was used to award a death sentence to 3 people in the killings which happened in 1981, right? Now, this killing happened in 1981, and the district court of the district of Manpuri, which is located in Uttar Pradesh, it has actually given the death sentence to 3 people, highlighting that this is actually a rarest of rare cases. Now, if you remember, Supreme Court has held in its earlier judgment known as Bachchan Singh vs State of Punjab in 1980 that death sentence is actually applicable, but you can't award death sentence just like that. Only in the cases which are rarest of rare, then only you can award the death sentence. So let us understand what are the grounds based on which you have to award, or the courts have to award the death sentence. Now, in Bachchan Singh versus Union of India case, the Supreme Court, it actually considered the challenge of whether or not death penalty is actually constitutional or not. Now, it actually upheld that death penalty is permissible in India, but it actually imposed certain conditions based only on which you can award the death penalty, and this is called as rarest of rare doctrine. And this will not be awarded in case there is a possibility of reformation for the convict, and only when you exhaust that there is no possibility that the convict will be reformed, then only the courts will have an option to award death penalty to certain convicts. Now this 5-judge constitution bench which heard the Bachchan Singh case, it did not specify the standards based on which you can and cannot give death penalty, but it actually laid down certain criterias which are called as aggravating or mitigating factors, and based on these criterias only, which is even evolving till date, the courts can actually decide whether to or whether to not award the death penalty. So let us understand what are these criterias, that is aggravating criterias and mitigating criterias. Now first let us deal with the aggregating criteria. Now aggravating criterias are the ones based on which courts can award death penalty, right? So this, considering these circumstances or aggravating circumstances, courts will actually move towards a decision of awarding death penalty. So what are these aggravating criteria? Suppose if the murder was done and it was done in a pre-planned manner, it was a calculative move and it involved extreme brutality, then the courts will award death penalty. Also, if the murder involved exceptional depravity means reprehensibly morally incorrect, right? So in extreme cases the courts will award death penalty, and also if the accused has been found guilty of murdering a public servant, a police officer, a member of the armed forces while they were on duty, or because anything they might have done lawfully while discharging their duty, it was being prevented by the murder of those public servants, then also the accused will be given the death penalty. So these are the aggravating circumstances which tilts the decision of the court in favor of giving the death penalty. Now what are mitigating factors? Mitigating factors are the one based on these factors the courts will not give death penalty. So what are these factors? Whether or not accused was under the influence of extreme mental or emotional disturbances at the time of offense, then the court will not provide death penalty. Also the age of the accused is considered, will not be given death penalty if they are very young or very old. Similarly, the probability whether the accused continues to pose a threat to society, this will also be considered, and if they do not continue to pose a threat to society, they will not be given the death penalty. Also, probability of reformation is considered. If the accused shows some signs that they will be reformed after their jail sentences, then also death penalty will not be given. If the accused were acting on the direction of other person, that this murder actually was done by accused but it was done on the directions of other person, then also the death penalty will not given. If the accused was believed that actions were morally justified, then this is not considered as a factor of giving death penalty. And also if accused suffers from mentally, or he is mentally unable to appreciate the criminality, or if he is of unsound mind, then also the death penalty is not awarded. So these are the mitigating factors. Aggravating factors, I told you, aggravating factors are the one which allows the court to award death penalty. Mitigating factors are the one which actually prevents the court from giving death penalty, right? Now actually after the Bachchan Singh case, we have seen that many criteria have newer being involved, right? Now new factors have been added to both of the lists. For example, age of the accused is considered. If they are of very young age, then the courts actually do not have the tendency to award death penalty because they have a life ahead and there is a chance that that accused might be reformed in the future. Also, the nature of offences are also considered. Cases where the collective conscience of the society is shocked by such cases, and then judiciary is expected to impose death penalty. We saw in the Nirbhaya case, the court actually gave the judgment that this was not just a crime against the victim, but it was a crime against the whole of society, which not just shook the conscience of the victim and its families, but the collective conscience of the society as a whole. And hence, in the Nirbhaya judgment, the court awarded the death penalty to the accused. Similarly, the possibility of reforms is also considered. Court will actually be provided with clear evidences that this particular accused has not or is not been able to be reformed, then only the court will actually give them the death penalty. Understood? So these are the factors that have been added after the Bachchan Singh case, and you can understand the factors will continue to be added as the time progresses of whether or not the courts will be allowed to give the death penalty. Now, when does courts consider these circumstances? Do they consider these circumstances at the hearing, or whether before they have established the actually the conviction of the accused, or after the conviction of the accused? Now, in Bachchan Singh case, the Supreme Court said that there must be a separate trial after conviction happens, so that the judges can be persuaded whether or not the death penalty should be given or not. And when this separate trial should take place, in several rulings the Supreme Court has held that it can be done on the same day, whereas in many other cases the Supreme Court has said that there should be a possibility of real, effective and meaningful hearing. So adequate amount of hearing should take place to allow the court to consider both aggravating and mitigating factors. Then itself, after the sufficient hearing, then only the court should award death penalty. Understood the conditions? Now let us move to the another article, a bit थर्ड पॉइंट ऑफ द मिटिगेटिंग फैक्टर. कौन सा है मिटिगेटिंग फैक्टर का थर्ड पॉइंट? प्रोबेबिलिटी ऑफ कंटिन्यूड थ्रेट टू सोसाइटी. सपोज इफ आई वाज अ टेररिस्ट, ओके, no I am not a terrorist. Suppose if a person was a terrorist, but that terrorist might be a very young age, okay, so what if that terrorist was accused of a crime of murdering a innocent person, but the court might feel that that terrorist has now reformed. After the reformation, that terrorist will not continue to pose a society. After we let him off, or after the completion of that sentence, the terrorist might live as a normal citizen. So in that cases, the courts will not give that particular terrorist a death sentence. Okay. Now a change in the change from polity. Let us consider this new article which appeared in yesterday's newspaper on page 7. As I was reading the newspaper today, I saw that this article was left out yesterday. Now this article has a very good implication. I'll tell you how. Now in this article, the Supreme Court has actually stated the decision made by Kerala High Court, as the decision of Kerala High Court actually issued directions to the state government to lay down certain measures on how you can allow the elephants to participate in a religious or a temple related functions. Now the judges of the Supreme Court, they remarked orally that the use of elephants in temple festival is actually the part of cultural tradition which is much more prominent in southern states like Kerala, Tamil Nadu, and the High Court order has affected stall this very celebration of the cultural tradition. So in this regard, this article made me understand certain points which are relevant from your exams perspective. So please be with me, I'll tell you how it is relevant. Now what are the rules around transfers and transport of elephant? Now in our discussions you might have heard that under the Wildlife Protection Act, elephants are categorized as a Schedule 1 species, right? Now any species which are given in the Schedule 1 of the Wildlife Protection Act, they can't be captured or traded, whether the wild or captive species, right? So this article or this particular section of the Wildlife Protection Act actually prohibits trading and capturing of the particular species which are mentioned in the Schedule 1 of WP Act, right? But there is an exception given in the section 12 of the particular act. It allows Schedule 1 animals to be translocated for special purposes. And what are these special purposes? These are education and scientific research. So indeed there is a prohibition on their transfer and trade, but it is allowed under certain special purposes for education and for the scientific research purposes under section 12. Now, who are captive elephants? Now, captive elephants, these are very prominent in our jungle economy, as they have played a very historical role in forest management and transportation of timber, in presence of estates of erstwhile royal families. As you might have seen, many royal family members, they are participating in a procession, but they are sitting on a very pet elephant of their own royal house, right? Now, these elephants, these are also present in the temple precincts for religious purposes, and they can be owned and they are under the special category. So this is also a exemption which allows captive elephants to participate in certain cultural and economic purposes. Okay, now section 40 subsection 2 of the Wildlife Protection Act, it prohibits the acquisition, possession and transfer of a captive elephant without the explicit permission or the written permission of the chief wildlife warden of the state. So technically you are allowed to transfer these captive elephants, but for that you need to take the written permission of the chief wildlife of the state. Now, what are the rules around transfer and transport of the elephant? Now, in 2021, our own Union Environment Ministry, it introduced an amendment to the Wildlife Protection Act, and it allowed for transfer of elephants for religious or any other purposes. And according to these latest rules, new relaxations are provided under which captive elephants can change owners or be transferred. For example, you can understand there is a term in Hindi, Hathi Mat Palo. Why is this term Hathi Mat Palo in it? They can't pet an elephant because petting an elephant requires you to spend a large amount of money, which is not under the response or not everybody have, right? So these include situations when the owner no longer have the possession or the means to maintain an elephant, and when state's chief wildlife warden they deems fit and proper to transfer the elephant under certain circumstances which will allow for better upkeep of elephant. So in these cases the transfer of elephants is permissible, but only after the written permission of chief wildlife officer of the state. Understood? So these are the reasons based on which you can actually transfer the elephant, you can actually keep the elephant captive for certain exemptions which are given under the Wildlife Protection Act. So if there is a species like elephant which is categorized under Schedule 1, however, they can be still transferred as per the certain exemptions, and I have told you this today. Considering brutality and collective conscience disturbances with Kolkata rape case, why no death penalty, sir? See, even I was wondering why this did not happen, but this is not under the ambit of UNI. This job is reserved for the judges themselves. They are getting paid for it. They are getting every allowances for it. So let them make the decision. This is not our decision. Now, let us see whether or not you can solve this practice question. Which of the following statement is or are correct regarding the Wildlife Protection Act 1972? It allows translocation of elephants for education and scientific purposes. Yes, correct. Captive elephants can be transferred without permission from authorities. Incorrect. They have to be transferred, but only with an explicit written permission of the chief wildlife warden of a particular state government. An amendment in 2021 allows the transfer of elephants for religious purposes with certain relaxations. This is correct. Using this exemption only, the temples in India can actually legally allow the elephants to take part in the religious and temple based proceedings, right? So second is incorrect, first and 3 are right. So C option is correct. Sarang, Shweta, Baga Spinks, Yashi, all of you are correct. Now let us move to this last article of the day. Why I took this last article of the day? Because every day we take articles from one measure or the other that is taken by the government. So I thought when we take or discuss, analyze articles from the government, why not also discuss this article which is undertaken or which is responsible or which actually tells us what the opposition is doing, so that opposition does not feel they are being left out in our today's discussion. So this article actually appeared in today's newspaper on page 6, and here Mrs. Sonia Gandhi actually demanded for hike in MGNREGA wages, and she demanded this hike in MGNREGA wages at a particular 0 hour in the Rajya Sabha. Now she is a Rajya Sabha member now. Srimati Sonia Gandhi, she says that the center government has systematically undermined the rural employment guarantee program, that is MGNREGA, and she has demanded rising the minimum wage to rupees 400 per day and number of days guaranteed under MGNREGA of work day to 150 a year, right? So in this regard, MGNREGA becomes important from our exams, and what is 0 hour? They become important from our exams perspective. Now let us quickly understand what is Mahatma Gandhi NREGA Act. Mahatma Gandhi National Rural Employment Guarantee Act, also known as MGNREGA. It is one of the world's largest work guarantee program that was launched by the Congress government back in 2005. Now this falls under the ambit of Ministry of Rural Development, and the primary objective of this particular legislation is that it guarantees 100 days of employment in every financial year to adult members of any rural household who are willing to do public work which are related to unskilled manual work. So remember, they provide 100 days of work guarantee to every adult member of any rural household who are willing to do unskilled manual work. Okay, and this scheme falls under the Ministry of Rural Development, and this MGNREGA provides the legal right to work, that you have the right to seek work by the government. So it is a right based framework. Similarly, right to education was brought, right to seek information was brought, right to seek food under the NFSA was brought. So these are right based entitlements that government is obligated to provide you these benefits, and if they are unable to provide you these benefits, they have to compensate you in one way or the other, right? Now the wages which are paid for the work which has been done under MGNREGA, it is based on statutory minimum wages which is specified for agricultural labours in a particular state under the Minimum Wages Act, right? So therefore the wages of the labour which is provided under the MGNREGA, it varies with different state. So for example, in states such as northeast like Nagaland, Arunachal Pradesh, the minimum wage which is offered to a labor is about 274 rupees, whereas in developed states like Haryana, the wages are offered at about 380 rupees or 382 rupees if I am not correct. So you can see the wages, it varies depending upon the state, and yearly the government revises these minimum wages based on the index, that is Consumer Price Index agricultural labor, right? Now there are many allegations that this CPI agricultural labor, it is formed with the base year of 86 and 87, and this is quite a old index. So why not start revising this wages as per the CPI rural or rural labor? Okay, so these are the demands that is based by the government, but right now the wages are amended every year based on the inflation figure of CPI agricultural labor, and the wages, they vary depending upon the state, right? Also, this is a demand driven scheme, that unlike the other schemes which are top down scheme, as government allows or passes certain budget based on which the scheme is offered to many beneficiaries, this is a demand driven scheme. And why am I telling you this is a demand driven scheme? And the demand for this scheme, it emerges from the lowest strata of the politics in India, that is through the Panchayati Raj institution, as these Panchayati Raj institutions are responsible for planning and implementing the work which is happening under MGNREGA. So suppose there is a pond which has been constructed in the village of Fulera, which is in Panchayat, okay? So that particular pond, the services of the labours will be enlisted, and these services of the labour will be enlisted under MGNREGA. So suppose the Panchayat of Fulera, it says that for the construction of pond we require 100 man hours of labour, right? So this demand will emerge from the Panchayati Raj institution of Fulera village, and it will be passed to the upper sections, and accordingly the government will provide for the budget for this 100 man hours. So this is how demand driven scheme actually works. Now this mandates that it is the Gram Sabha which recommends the works that are to be undertaken, and at least 50% of the work, they must be executed by the Gram Sabhas themselves. And if in that case, if the Panchayati Raj institutions are not able to provide the work to people who are demanding the work within 15 days, so in that case unemployment allowances will be provided to people. So this is what right based entitlement means, that if government is unable to provide them with the work, they have to provide them with the unemployment allowances. Also, at least 1/3 of the beneficiaries of MGNREGA, they have to be women. This is one of the major provisions under this act, right? Now, I told you, right, Srimati Sonia Gandhi raised this issue in the 0 hour. So what is 0 hour, or how are questions actually asked in the parliament? Now, for asking questions to the government, there is a general provision known as question hour, which is actually happening in the first hour of every parliament sitting, and actually first hour of every parliament sitting is slotted for the question hour purposes, and during this time the members ask questions and the minister usually give answers. Now in most cases these questions are pre-planned, and you have to give a formal notice before some days in order to ask a question in the floor of the parliament, and if you ask questions suddenly, the minister is not liable to give the answer then and there itself, okay? Now, in case of certain exigencies, there is also provision of 0R. What is 0R? That unlike question R, 0R is not mentioned in the rules of parliament. It is actually an informal device which is available to the members of the parliament to raise any matter without giving any prior notice. Now, this 0R, when it happens, that after the time question R gets over and till the time agenda for the day is taken up by the parliament, between that period, the Parliament allows for 0R to function. So this is actually the regular business of the house, and between question hour and the agenda of the day, the gap, it is used for 0R purposes, and it is an Indian innovation in the field of parliamentary procedures, and it has been exercised since 1962. Understood this particular scheme? What is question hour? What is 0R? Now, let's see if you can solve this particular question. Consider the following statements regarding Mahatma Gandhi National Rural Employment Act. It provides for legal guarantees of 100 days of wage employment in financial year to every rural household whose adult members volunteer to do unskilled manual work. This is a straightforward statement and correct. The wages under MGNREGA are determined by central government and are uniform across all states and union territories. This is incorrect. These are determined by state governments and these are not uniform. These vary across different states, and at least 1/3 of the beneficiaries under MGNREGA must be women. This is indeed correct. So first and third is right. We have to identify correct statement. Therefore, option B here, yes Sarang, yes Baga Spinks. These two options are correct. Now, this brings the end of our today's session. The notes for this session will be available on the Telegram channel ATS Live, and this is your practice question for the day. Do let me know the correct answer of the practice question after the session ends in the comment section, and also please do not forget to give us a thumbs up, as it helps keep me motivated, because this work on a daily basis is very tiring, and the energy that I got out of reading today's newspaper, because there were plenty of polity articles, this is usually not present every day. So for that I need a lot of thumbs up from your part. So I'll see you again tomorrow at 4 p.m. Until then, please keep revising, please keep reading, and more importantly, keep writing your answers. Okay, so I'll see you again tomorrow. Have a very good evening and good